So, hello, my name is Bradford Sussman, and you're watching Media Reporter. Today, I'm interviewing Professor Heather Cucolo of New York Law School. Professor Cucolo?
Hi, thanks. I'm happy to be back again and chatting with you.
Well, thank you. And actually, this is, in our last discussion, this was actually, I think, the first question I asked you then, but I think it's worth going into again because there may be people tuning in for the first time. Why? Why do you focus your practice and focus your academic work on sex offenders, and what led you to choose that course in your law career?
Yeah, and I think that's a very valid question, and I get asked that often. And I think what first drew me to this area was the intersection between constitutional law and criminal law and civil commitment law. And I found that fascinating. And all of those aspects of the law were something that I was really interested in my studies. But I'm asked often why. Why would I represent a population as sort of as hated and as despised as individuals who have committed sexual offenses? And that's a very complex answer, but sort of as I have told others at cocktail parties and as I tell my students, I think one of the most important answers is, if not me, who? Because I think that these individuals are entitled to the best representation that they can possibly have. And you know, it takes someone that really has a strong belief in the law to be able to and want to represent these individuals and make sure that their constitutional rights are upheld.
Mm-hmm. And in our last discussion, we focused primarily on civil commitment of sex offenders. Mm-hmm. And I was wondering if have there been any interesting developments since our last discussion, and how has sort of your interest in civil commitment informed the work that we're going to talk about today, your work with sex offender registry issues, and also how the media impacts issues with sex offender post-incarceration treatment?
Well, to the first point, there really has not been anything all that significant recently regarding the civil commitment of sex offenders, although there have been some interesting issues that have kind of come up in the courts. So I think the last major case that came out, of course, was the United States versus Comstock case that was a decision by the Supreme Court basically upholding a federal civil commitment statutory scheme. And, you know, this fell upon a lot of focus on the powers of Congress, but basically sort of as far as what we're concerned with in terms of sex offenders and civil commitment, what it really just says is that this area of the law is not fading away, is not going by the wayside, that clearly it is still being upheld, still found to be constitutional, and is enacted on a federal level at this point. And what that does is that individuals that are in federal prison that are designated sexual predators, sexual offenders, are, if the state that they're going to go back to, let's say, does not at that time have a civil commitment statutory or statute or statutory scheme, that's when the federal government might step in and decide to civilly commit that individual past their prison sentence time. So other than that, something that's interesting going on in Minnesota, there's been a case that is coming up through the courts, sort of looking at their civil commitment program and questioning why within the, I think, 15, almost maybe 20 years, 15 years that it has been in existence, why literally, I think, no one has been released, or very few individuals have been released. I think since that litigation began, Minnesota did release a couple of their committees. But up until that point, there had been basically no releases whatsoever. And that calls into question some of the things going on in terms of civil commitment, and calls into question whether or not treatment is actually works, is actually something that can, in effect, reduce this risk. It calls into question the constitutionality of holding these individuals past their prison sentence based on this diagnosis, based on this determination that they're going to commit an offense in the future.
And have there been any studies on sex offenders, sort of the condition of their mental health post-civil commitment? Is that continuing to be looked at in sort of a clinical way, or not so much?
Well, no, there have been plenty of studies. I think the studies, though, that are significant to this issue are the studies taking a look at reoffense rates and recidivism rates. And what those studies have found primarily is that reoffense rates for sex offenders has been shown to be low. And in fact, not only low, but lower than other types of criminals, than individuals that commit robberies, or individuals that petty theft, petty crime. And that in itself, I think, the recidivism rates, the reoffense rates being low, sort of begs the question, is it appropriate then to civilly commit this population or this cohort of individuals, when in fact their reoffense rate out in the community has not been shown to be high? So those studies are certainly relevant in that.
This actually brings up an interesting question, or it raises more questions than it answers in terms of the why are people not recommitting, but I think that's a good segue into our next topic. I was wondering if you could give us just the basic background and history of sex offender registries, and just some background on sort of your studies with or your work dealing with sex offender registries.
Well, sex offender registries and sort of the idea of tracking sex offenders has been around for a long time, but they sort of really began to make a real impression and really begin to sort of spiral out in this country kind of post-Megan's Law, post the enactment of Megan's Law in New Jersey, and absolutely post the Adam Walsh Act, that is the federal act. And basically residency restrictions sort of flowed out of community notification and registration. Okay, so community notification and registration, again, states have enacted laws, ordinances, statutes in order to track offenders once they're released into the community. And they track them by having them register with the local police, information such as address, description of appearance, whereabouts, license plate numbers. There's a whole slew of information that states can mandate that offenders must detail and relay to local authorities. Other states have used global positioning systems, GPS tracking, which tracks the individual. They have to wear a device that then apparently is tracked via satellite. There are a handful of issues with that type of technology in terms of whether or not it's effective, which it has shown not to be, because it's not really tracking. They're not looking at it in real time. It's sort of an after. If a crime is committed, they might look back and see, are any of the registered sex offenders, were they in that area at that time? Residency restrictions, though, came about sort of as states and communities were in an we're crying out for ways to keep this population away and keep sex offenders out of their communities. So what they decided to do was to enact laws and ordinances that would say that an offender coming out after convicted of a specific offense, specific sexual offense, cannot reside within a designated area. And usually that area is anywhere that's close to where children may be. Schools, playgrounds, churches, daycare centers. And these residency restrictions that prevent offenders from living within whatever it's been designated, 200 feet, 2,000 feet from these types of establishments, these restrictions are for all offenders, regardless of the underlying crimes that they committed. So regardless if the offender has had any history with abuse against children, they are restricted from living near children. Mm-hmm. And then this has been something that sort of spiraled, and states rushed to enact residency restrictions. And as time has gone on, again, post Megan's Law enactment in the 90s and working into the 2000s in the 21st century, as time has moved on, courts have begun to step back a little bit from these restrictions, finding that they're extremely harsh. They've been shown to amount to what many scholars and academics have called to be banishment. In fact, that we're banishing these individuals. They actually, because they're being restricted out of so many areas, they're finding that they have nowhere where they can live. And there, of course, a couple years ago, out in the papers was all of the discussion about what was going on in Miami and what was going on in Florida, where offenders were being restricted out of areas and they were setting up tents under a bridge. Basically, that was the only place left where they were able to live. And so when you look at this from a clinical perspective, clearly when you look at it from a legal perspective, we find that there's many unconstitutional aspects about these residency restrictions and the harshness of some of these laws. But looking at it from a clinical perspective, by zoning individuals out of these areas, in effect, we're doing more harm than good. We are sort of preventing appropriate resources, appropriate treatment, individuals that are not allowed to live with positive influence, positive family members because they're zoned out of that area, or individuals that had a stable residence before they went to prison are unable to go back to that stable residence. And these sort of are issues that cause the individual, cause the offender to sort of feel isolated, feel less than worthy, feel depressed, feel anxiety, hopelessness, all of these things that, if you look at sort of the treatment trajectory and look at sort of the effect of how we try to understand individuals that commit sex offenses, all of those things that I just mentioned are potential triggers that lead to the whole process of them, again, wanting to reoffend.
It's interesting that it's sort of these processes or these registries can almost act or can act as a bar to integration into society. But I guess I recently it's Oscar time now, and I recently saw Les Miserables, which I had seen many years ago on Broadway, but I guess I had forgotten what a good story it was, and or I looked at it now through post law school eyes and found new interesting elements of it. But it's really in its essence, other than the other sort of just criminal justice type fairness issues involved, it's about a parole system that prevents reintegration into society. Now, for a guy that was put in jail for 20 years for stealing a loaf of bread to steal, to feed his child, maybe that's something that we should be really concerned about. But with sex offenders, do we really want them reintegrated? You sort of started to get to the point, but with feeling that it makes them more likely to reoffend, it increases the likelihood of recidivism. But are there other options? Other than integrating them into society?
Well, again, you're not alone. Most members of the community, most people in the general public do not want them reintegrated, do not want them in the communities, do not want them back into their neighborhoods and towns. But when you say, other alternatives, well, why do we treat this cohort of individuals, why do we treat this population differently than any other population? Any other criminal population, they serve their prison time, they're released, often on parole and probation, sometimes to halfway houses, and then back into the community that they came out of. And constitutionally, how can we justify treating this population differently? And what is it? What is it about this population specifically that warrants our desire to create and enact different rules, different laws, different ordinances to keep them away from us, to banish them in essence? And talking of great stories, great movies, as well, this sort of community notification and registration and residency restrictions have been equated to sort of the scarlet letter, and basically they're branded for life.
And how do you think? So, in essence, do you think that registration makes a person more likely or less likely to reoffend? And are they keeping us safe, or is it easy to make a claim either way based on the data that's available?
I mean, we have to look at, well, what exactly do we want to be safe from, first of all? And we have to look at, what does this mean by safety? Before we even think about this or talk about this, we have to understand what the facts are, what we know to be the facts about sex offenders. And what the facts have shown is that the majority of offenders are familial offenders, incest offenders, people that offend within a close-knit community, in a close-knit situation. So it's not sort of this stranger child rapist that we've based our laws on. And so you got to look at sort of the facts about sex offenders. So when we look at the type of offender, when we look at the reoffense or recidivism rates as being low, and also the fact that oftentimes when these are these incestual types of situations, familial situations, they're not reported as much. And so that kind of has some sort of effect on the low reoffense and low recidivism rate. But then you ask yourself, does it in fact, do these types of notifications and restrictions really have any effect on what we know factually about sex offenders? And you ask, if our goal is safety, and the question is, have our laws kept us safe? The answer seems to be no. The answer, and no in the sense of we're no safer with these laws than we were before these laws. There was a study done that looked at sort of offenses 10 years post Megan's Law and 10 years prior to Megan's Law. And they kind of found that there was absolutely no difference in terms of the number of offenses, amount of offenses. In fact, there was somewhat of a decline leading up to Megan's Law, and somewhat a decline after Megan's Law. But certainly there was no notable difference in terms of the reoffense rate or the offense rate for sex offenses in the community. And certainly this was all over the newspapers, and especially in New Jersey, they took a look at this and said, Megan's Law, our notification, our restrictions are not making us any safer. And the response was, well, that's not what they were intended to do. The response was, what they were intended to do was just to make us aware. To make us aware so that we could go into the registry and see, okay, who in our neighborhoods was convicted of some sort of offense. Sometimes we don't even know the specifics.
Right.
We have known nothing about the crimes that were committed. All we know is that they are a registered sex offender. And if that's the purpose, then what does that really offer us? The purpose of just knowing they're there? Many people have said, who we need to be concerned with are the individuals that are not registered, the individuals that are not complying with the law and complying with authorities.
And has there been any examination of sex offender reintegration and their success in sort of leading productive lives. I don't know how you'd quantify that, but has there been any examination of that pre and post Megan's Law, or even just post Megan's Law?
I mean, again, I think that in terms of what is going to, if we're going to integrate these individuals, if we're going to say that they have the right to enter back into the community after they have served their criminal sentence, or post-civil commitment once it appears that their risk has been reduced sufficiently, then we have to take a look at sort of how we're going to treat them into the community. And it seems to be counter-therapeutic to isolate them, to, in essence, again, banish them, put a scarlet letter on them, take away any support system that they might currently have with positive family members, positive supports possibly, and as well as, prevent them from finding gainful employment. All of these things, I think, in anyone is going to lead to feelings of depression, feelings of low self-worth. All of these things have the potential to initiate a desire or a motive to engage in behavior that is not going to be beneficial.
Just to play devil's advocate on that point, Governor Cuomo and others have called for example, reductions in the penalty for marijuana possession, because there's a sense that in conjunction with stop and frisk policies, that marijuana convictions for small amounts of marijuana were preventing a whole, massive numbers of people from advancing in life because they would have this mark on their record. To what extent, just maybe technically even, what are the differences between being on parole for any other crime and being on parole as a sex offender, and don't all, people that have been convicted of a crime have the same sort of problems, and why should our concern go out to sex offenders, or what are the technical differences between being on a sex registry and just being on parole or on probation?
Certainly anybody with a felony is
Right.
going to have an issue, but there is something uniquely different when we're talking about someone with a sex offense felony. They're looked at differently. Again, they're looked at as child molesters, even though their offense may have nothing to do with children. They're looked at individuals that are compulsive, impulsive, can't control themselves. These are individuals that we believe, they have violated the ultimate personal intimacy, space, trust, all of those things by acting out sexually. And so I think we think the worst, clearly, and we consider these crimes to be the worst crimes. And there, again, there's just such a different sort of connotation, such a different idea of the individual that we place on those that have been convicted of sex offenders. But interestingly enough, when you talk about sort of the decision to not prosecute under a specific amount of marijuana, I think that was also partially due to the fact that our prisons were extremely overcrowded, or our jails were extremely overcrowded because of these types of arrests that really, again, I guess were not seen to be something that was where we needed to designate our resources and our time. And if you want to talk about, if we want to talk about financial expense, overcrowding, we have to look then to these civil commitment centers for sex offenders as well that have been spiraling out of control. California, Florida, Minnesota, Kansas, even New Jersey, in terms of the amount of money spent per offender to keep them in these civil commitment treatment centers, upwards of $200,000 per offender per year of taxpayer money. And the fact that without releases at any really reasonable rate, it's just piling up. You need to build more resources, build more facilities, hire more clinicians, more treaters, more social workers. Depending on how they're being monitored, more corrections officers are going to be in. And, you know, all this does is sort of generate huge financial burdens on states that are already, you know, insignificant, having significant issues.
Yeah, this brings up an interesting thought, and I think it again segues well into other work you've been doing. What's the interplay between sex offender reintegration and the media, and then the interplay between the media and sex offender registries? Because I know you've been doing work on.
Absolutely, yeah. This is something that I've sort of been looking at for a while now and researching, and recently just wrote a paper with Professor Michael Perlin talking about sort of how the media has influenced these laws and legislation, which is nothing new. Scholars, academics, we've talked about sort of how the media and this moral panic, this frenzy over the stranger child rapist offender has influenced our legislation. We talk about Megan Kanka and the horrific murder of 7-year-old Megan by a convicted sex offender. We talk about you know, the Adam Walsh Act. Of course, you know, Adam Walsh was abducted from a mall early on by someone who then killed him. And these horrific incidents that we hear, and they sort of evoke these emotional responses and this call for action. So again, this is nothing new, but what I wanted to consider and what I have been considering and looking at is how has the media possibly changed, or the mass media changed and shifted in some ways in terms of how they will display what's going on in the sex offender world, and whether or not that has had any effect on repealing any of our laws or calling into question any new legislation. And in a nutshell, very basically, is what I believe and what I think I've seen is that the media has been much more open in discussing the factual information about low rates of recidivism, low rates of reoffense, the fact that treatment is questionable, all of the problems involved in these civil commitment centers. Taking a look at sort of the cohort of offenders being those that are primarily familial incest offenders, focusing very much on these isolated populations, let's say the Catholic Church, the Hasidic community in Brooklyn, the coaches out of the Penn State scandal with Sandusky, looking at the Boy Scouts, all of these sort of different types of individuals that we trusted, that we knew, that we thought highly of, you know, that have then become these child predators, so to speak. Moving away from this panic over this stranger sex offender that we don't know, that could come and take our children at any moment. And so some of these shifts and whether or not it has had any influence on legislation, very complex but very interesting discussion and way to think about it. And I don't know that it has had much of an influence. I know that, you know, post-2007, post-New York, that I think was one of the last states to enact a civil commitment statute, you know, no states have jumped on board. Whether or not that's due to our feelings or our factual knowledge about sex offenders, or whether or not it's just due to the exorbitant amount that it costs to run and to enact these statutes, to run these institutions. Certainly it has not seemed to have much an effect on community outcries for the fear of these individuals being near us, being near our children, being near our women. I think that the emotional responses and the fear cannot be overridden, even by, you know, common knowledge or mass media factual information showing that the threats that we believed are there are not the threats that we really should concern ourselves with.
Well, I'd love to spend more time on this because I feel like we're just opening up a huge issue.
Yeah.
But I guess it's nice to see that the media is moving in the right direction. I was surprised that in a way.
In some ways, yes.
Right.
In some ways.
And hopefully we can look into this a little more in the future. This is again Bradford Sussman with Media Reporter. We've been talking with Professor Heather Cucolo, and thank you for spending time listening to these issues.
That's great. Yeah. I know.
I'm gonna be